prosecution would like to offer a stipulation before we begin.
All right, well, let me make sure the defense ready to proceed.
Your Honor, we would like to make a motion to eliminate before we proceed.
First of all, would the prosecution introduce yourselves to me and to the jury? And then we'll do the prosecution's motion, then the defense motion. Okay.
My name is Robert Lang.
My name is Roberta Alfonso Dozier.
My name is Dina Marshall.
My name is Eddie Stevens.
All right, let's go slow now. All right, Robert Lang and
Roberta
Roberta.
Alfonso Dozier.
Okay.
Dina Marshall.
And Eddie Stevens.
Okay. All right, now I'll hear the prosecution's motion. Remember, we got 7.5 minute time limit on motion.
This should be fine, Your Honor. There's been a stipulation agreed to between the parties before we even met tonight. It's simply that it's been agreed that between the parties that, first off, Mr. Thomas Hanley will be a black male, and any pertinent testimony to the basis of his race will be altered to reflect that change. And also, the testimony of Thomas Hanley as to the agreed plan conspired between him and Emma Sams will show that they planned that Emma Sams would report to the police that a Caucasian male had robbed the liquor store.
Defense agree to that?
Yes, sir, we do.
Okay.
And the second stipulation is that Officer David Patton will be changed to a female and will become Officer Donna Patton, and any pertinent testimony to the basis of her sex will reflect this change.
Very good. Defense has a motion.
Yes, Your Honor. At this time, we'd like to introduce a motion in limine to exclude any evidence related to the letter found by Officer Patton at the defendant's house, and we ask this excluded for evidentiary reasons under 801, 403, and 401. First, we believe that the letter is hearsay because it is an out-of-court statement used to prove the truth of the matter asserted, and that the relevance of the statement depends solely on whether or not it is true. It does not fall under an 803.18 exception as an admission because there is no proof that it was written by the defendant. And according to Bourgeois versus United States, the proponent must prove that it was by a preponderance of the evidence. If you find that the envelope is not hearsay, then we feel the probative value that the envelope might have is substantially outweighed by the risk that Ms. Sams might be unfairly prejudiced by an erroneous interpretation. In State versus Sawyer, the court ruled that the admission of a single hair found in the murder victim's apartment had the danger of unfairly prejudicing the defendant, which substantially outweighed the probative value, even though it matched the defendant's hair in all 20 observable characteristics. And in the case at hand, the prosecution can't even prove that it was written by the defendant. And if you feel that the probative value, that the substantial prejudice is not outweighed by the probative value, then we've prepared some limiting instructions. We would like you to read to the jury before the evidence is introduced.
Okay. What says the prosecution?
Your Honor, we would argue that this is not an assertion asserted for the truth of the matter. What is relevant is rather that the words exist on the piece of paper, not whether there is any truth to those words. However, if you do believe that this is a hearsay statement under 801, it does fit under the 803.18 admission exclusion. It is the party's own statement, and as such, we can use Rule 901 of the Florida Evidence Code to authenticate this as belonging to the defendant. There's going to be testimony as to the location where it was found, the property where it was found belonged to the defendant, and also the distinctive characteristics in conjunction with the circumstances of this case would all tend to authenticate the note as belonging to the defendant. Therefore, it would come in under the 803.18 exclusion as an admission because it is the party's own statement. The advisory committee notes to the federal rules actually state that there's no guarantee of trustworthiness required, which is not included in the Florida rules. The Florida rules do not address that issue. As far as the Bourgeois case, here it says in Bourgeois also that you must only presume that this piece of evidence is unreliable, but that is a rebuttable presumption. The defense can still attack the probative value. The declarant is available for cross-examination, and in fact will be available for direct examination by the defense, as it is the defendant. And as far as Sawyer applies here, The defendant is available in the courtroom. The Sawyer standard said that it was a preponderance of the evidence, which is not that high a standard as the probative value involved. And actually, their argument goes more to the weight of the evidence, not to its actual admissibility. Admissibility is a much lower standard than probative value. And we would argue that under 403, this is not highly prejudicial enough to keep it out, because it would not encourage the jury to make their decision based on an emotional issue rather than factual, and that questions of fact are to be sent to the jury under Florida Rule 958. Factual questions are to be jury questions. And again, this is an issue of weight of the evidence, not admissibility of the evidence. Thank you.
Any response?
Again, we don't feel that they can prove that it was written by the defendant, but if they would like to proffer that, they can go ahead.
All right, the motion is denied, and we'll see what they come up with later.
Would you like us to give you the limiting instructions now?
No, not right now.
Okay.
Is the prosecution ready for its opening statement?
Can I take a second, Your Honor?
Sure.
Please, the court, counsel. Members of the jury, 3 words: conspiracy, fear, disloyalty. That's what this case is all about. Emma Sands has been charged with grand theft. There are 3 elements to that crime. First element is that Emma Sands committed the crime, that Emma Sands knowingly and unlawfully took the property of another person. The statement proved that she did. She stole money from Wiley Fox. Second element is that property that was stolen or taken from the individual is worth more than $300. It was. You're going to find that it was over $3,400. And thirdly, that Emma Sands, when she took the money, intended to deprive Mr. Fox and to take the money as her own. The state is prepared to prove to you all 3 of those facts. My co-counsel and I, Roberta Alfonso Dozier and Robert Lang, represent the state of Florida. And we have the burden of proving to you, to the exclusion of and beyond any reasonable doubt, that Emma Sands committed this crime. But in order to do that, we're going to introduce you to a few people. First person that we're going to introduce you to is a man named Thomas Hanley. Thomas Hanley is going to tell you about how he met Emma Sands. He's going to tell you that a while ago, he was working to help repave the parking lot at Wiley's liquor store. And while he was repaving the parking lot, he came upon another employee of Wiley's liquor store, one Emma Sands, the defendant. And during that, he started talking to Emma Sands. Got to know each other. He's going to tell you that they went out several evenings together and had conversations. And what the conversations focused on, he's going to tell you, is that they both had financial problems. They were both strapped for cash. And in that financial problem, he's going to tell you, arose a plan. The plan he's going to tell you arose is that they were going to rob Wiley's liquor store. He's going to describe the plan in detail for you. They would meet, go in, take the cash as she had access to it, divide the cash, and then he would leave. And then she would come out after he had left and say that a robbery had taken place. But when the plan was that she was supposed to report that the robbery had taken place by an individual she had never seen before, a white male. You're going to hear that this actually took place, but went down a little bit different than Mr. Hanley had planned with Emma Sands. On December 1st, Mr. Hansen showed up at Wiley's Liquor Store a little before 10 o'clock in the morning. He went to the front door. He's going to tell you that he knocked on the front door. And Miss Sands came to the front door, let him in. They went back to the office, and back at the office, they took the money that was out, split the money, Mr. Patton left. But as you're going to find through the evidence that after Mr. Hanley left, Miss Sands walked out of the store, and she said that a robbery had taken place. She told the police the person that had robbed the store she knew only by the name of Tom. Okay? Now, at this point, police asked her if she knew anything else. Her story, as you're going to hear, is that Tom came to the front door, asked to come in because he had to use the bathroom, went back, went to the restroom, and then after using the restroom went into the office, held a knife to Miss Sands' throat, and stole the money, and then escaped through the front door. It's going to be the story that you're going to hear.
Objection, Your Honor. May we approach the bench?
Yeah, we'll just do it in open court, though, for benefit of everyone.
As you're well aware, we have no burden to prove anything, and for the prosecution to suggest that it should be grounds for a mistrial.
Is that what you suggested?
I don't think that I suggested anything to
By
this.
suggesting what Emma Sands' story will be.
Can I rephrase?
Well, you can respond to the objection.
My opening statement is going to the deposition of the police officer that was taken at the scene of the crime.
The motion is denied, but stick to what the evidence will show.
Yes, Your Honor. At the scene of the crime, another individual was there. An individual who came up to Officer Patton after the situation took place. I apologize. After the situation took place, the police arrived. The police were sitting there. There was an Officer Patton, who you will also meet today. And Officer Patton was sitting at the scene of the crime, and he was talking to Emma Sands, the defendant. And during that time, Officer Patton will tell you what was said. But during that conversation, another individual came up, an individual who gave the license plate, a license plate number, to Mr. Officer Patton. He was tracked down, and at that time, tracked down to an individual named Tom Hanley, the same person that I've just told you about, the same person you're going to meet. The evidence will show that 3 days later, he was found down in Miami. He was arrested, and at that time, Mr. Hanley told the police officer that he would like to confess. He was read his Miranda rights, as you will hear, and he gave his testimony. You're going to hear it again today. The evidence will show that he was not promised anything, and in that he is going to tell you his plan, the plan that he and Emma Sands shared. You're also going to see that he told the story about Emma Sands and he conjuring up the plan together. And as you're going to see, the stories will not balance as to what the defense will say happened and what we will say happened. But I would like to have you listen very closely, because the police came back to Pinellas County and they called in Miss Sands, read her rights, and then they went to her home. And when they went to her home, they went into her home and they found certain evidence that's going to corroborate with Mr. Hanley's testimony. I ask you to listen for that very closely, because in this case, we The state must prove to you beyond a reasonable doubt, to the exclusion of and beyond any reasonable doubt, that Emma Sands committed this crime. And you must find that she committed each one of the elements that I told you early. And you're going to find this. However, in order to do this, you must consider the evidence closely. You must listen to all of the evidence. Consider just what you hear, what you do not, what any lack of evidence that might come into the courtroom, or any conflict of evidence, and then you must weigh that evidence. And that's where you must make your decision from. You're going to hear the entire testimony and evidence, and I ask you to listen to it very closely, because it will be your responsibility at the end of this trial to decide the guilt of Emma Sands. And I thank you for your attention.
Thank you. Defense have an opening.
Yes, sir. We do. May it please the court, counsel, members of the jury. My name is Dina Marshall, and this is co-counsel Eddie Stevens, and we represent Ms. Sands in this case. This is Miss Sands. She is a 28-year-old single parent. She has a 5-year-old son. She has a good job at Wiley's liquor store and has worked there for the last 3 years. Emma's made many friends in the community, from church and the Cheyenne Social Club. You'll hear testimony that Emma has a good reputation in the community. On December the 1st, 1994, Emma was more terrified than she had ever been in her entire life. You see, around 9:55 a.m. on that unforgettable morning, Emma was the victim of an armed robbery. Emma's going to take the stand today. She's going to sit right here, and she's going to tell you that on December the 1st, Mr. Thomas Hanley put a knife to her throat, pushed her down, grabbed approximately $3,400 in cash, and ran out the front door of Wiley's liquor store. Emma's going to tell you how afraid she was, how hysterical she was. Emma panicked. She didn't stop to turn on the alarm in the store. She just ran outside to get some help before the robber got away. Emma will tell you that she knew who the robber was. It was Thomas Hanley. She had seen him patching the parking lot outside Wiley's liquor store back in November. Emma didn't like Mr. Hanley, and she'll tell you that she had reason not to like him. Mr. Hanley has made unwelcome advances toward her on numerous occasions. Emma will testify that on December the 1st, she got to the store early so she could open by 10 a.m. She removed approximately $3,400 from the safe, stacked it on the desk in the back office. But she was interrupted around 9:55 a.m. Mr. Hanley knocked on the front door. Emma let Mr. Hanley into the store to use the bathroom. Emma will explain to you that to go to the bathroom, Mr. Hanley had to walk right by the office. And that's where the $3,400 was sitting, right there on the desk. Mr. Hanley came out of the bathroom, but he didn't leave. He came into the office, threatened Emma with a knife, pushed her down, grabbed the $3,400, and ran out the front door. In this case before you, the prosecution has the burden of proof beyond and to the exclusion of every reasonable doubt. The evidence simply will not lend itself to this high standard of proof. Members of the jury, Emma Sands is here today to let you know that she is innocent of this crime. During this trial, we ask that you pay special attention to two things. One, the inconsistencies in the testimony, and two, the credibility of the witnesses. If you find that you have any reasonable doubt about any of the evidence, it is your duty to return a verdict of not guilty. Thank you.
Is the prosecution ready to call their first witness?
Yes, Your Honor.
You may proceed.
The state calls Thomas Hanley.
You're sworn.
Will you please tell us your name and your age?
My name is Thomas Henley. I'm 34 years old.
And where do you live, Mr. Hanley?
Currently, I reside at the Pinellas County Jail.
Have you been promised anything for your testimony here today, Mr. Hanley?
No, ma'am.
Do you know the defendant, Emma Sands?
Yes, I did.
Where did you first meet her?
I first met Emma when I was working on a crew patching the parking lot at Wiley's.
How well did you get to know her?
Ma'am?
How well did you know her?
We became friends and we started meeting in the evenings.
When you saw each other in the evenings, was this on a casual, personal basis?
Yes, ma'am.
So you spoke about issues outside of work.
Yes, we did.
Would you care to tell us about some of the things you may have talked about?
Emma mentioned that...
Objection, Your Honor, hearsay.
Your Honor, he's going to testify to his own statements.
It's still an out-of-court statement being used to prove the truth of the matter asserted, whether he made that statement or not.
He is available for cross-examination, and this is a conspiracy theory. They would be co-conspirator exception under 803.
I thought the charge was grand theft, not conspiracy in this case.
The theory of the prosecution is a conspiracy theory, Your Honor.
Who was present at the time these statements were made?
Well, these are statements as to Mr. Hanley with the defendant, what they spoke about.
All right, we'll let it in.
Go ahead, Mr. Hanley. What did you speak about?
Emma mentioned that her ex-husband wasn't paying child support for one child, and I mentioned that I was strapped for money.
So you both had money problems?
Yes, we did.
Can you tell us if you said anything else about these money problems?
Yes, well, we talked about our money problems, and a plan evolved where we planned to steal money from Wally's.
Can you please describe this plan?
The plan was for I to meet a few minutes before 10 a.m. at Wally's, and Emma was supposed to let me in the front door, and once we get in, she's going to lock the door, and then we go and into the office where the safe is, and she would open the safe and take some $1 and $5 bills and spread them around, and we'd get the rest of the money and divide the money among ourselves.
And what were you going to do once you divided the money?
After we divided the money, then the plan was for Emma to meet me in Miami at Miami Beach Hotel on December the 5th at 10 o'clock, and we're going to meet at the hotel, Miami Beach Hotel, and I was supposed to meet her at 10 a.m. in the lobby, and we was going to celebrate our success.
Did your plan work, Mr. Hanley?
At first it did.
Could you explain?
On December 1st, I arrived at Wally's, and I parked in the back, and I walked to the front door, and I tapped on the front door, and Emma came, and she let me in, and she locked the door, and then we went to the office where the safe is, and she unlocked the safe, and she pulled out a few dollars, $1 and $5 bills, and spread it around on the floor and put some on the desk. And she also had some checks and spread them around too. And then she pulled out $3,400 out the safe. And then I took $1,700 and I put it in my pocket, and she put $1,700 in her purse, which was also in the office.
Okay, and what did you do after you had divided the money?
After we divided the money, we went to the back door. Emma unlocked the door. I went out the back door, and I don't know if she locked the back door or not, but I got in my car and I left.
Okay. Where did you go?
I went to my girlfriend's apartment.
Okay. And what did you do once you arrived there?
Once I arrived there, I I called an airport limo to take me to Tampa Airport.
And why did you go to the airport?
Because again, on our plan, Emma and my plan was to meet in Miami, so I was going to the airport to catch a plane.
And did you fly to Miami?
Yes, I caught a 4:20 flight to Miami.
Where did you go once you arrived in Miami?
I went to my brother's house.
And once you got to your brother's house, did you hear from Emma?
No, I didn't.
Can you tell us what happened?
On the third day after the robbery, a police officer came by and arrested me.
When you were arrested, did you make any statements to any officers?
Yes, I did.
And why did you do this?
I did this because he told me that she told the police that I robbed the place.
And why did this, you sound upset, why did this upset you?
Because I didn't rob the place.
Well,
We planned on taking the money together.
okay. So you do admit that you did commit the robbery?
Yes, I do admit that, but we planned it together.
Okay. Did you at that time, on December 1st now, not at the time you were speaking with the officer, by the way, did you identify the officer with whom you spoke? The one to whom you confessed?
Yes.
Was it a Miami officer or was it an officer from here in Pinellas?
The officer was from Pinellas County.
Do you recall the name of the officer? It's okay. Okay, we're going to have the officer on the stand. Did you, at the time on December 1st, at the time of the robbery, or at any other time, threaten Emma Sands?
No.
Did you at any time carry a knife or any other weapon?
I never carried a knife that day or any other day.
Okay. When you were speaking to the Pinellas County officer, did that officer promise you anything for your confession?
Nothing. I voluntarily waived my Miranda rights.
Have you been promised anything since that day?
No.
Are you familiar with the layout of Wiley Fox's liquor store?
Yes, ma'am.
And are you familiar with how it looked on December 1st of last year?
Yes.
Your Honor, permission to approach the defense and then the witness. Thank you. Mr. Hanley, I'm showing you State's Exhibit B. Do you recognize this?
Yes, ma'am.
Do you recognize it as representing the layout of Wiley Fox's store on December 1st of last year?
Yes.
Is this a reasonably accurate representation of how it looked?
Yes, it is.
Will this diagram help you explain what happened that day?
Yes.
Your Honor, we offer State's Exhibit B into evidence.
Any objection?
No objection, Your Honor.
Mr. Henley, will you please use this red pen I've just handed you and show us what you did on December 1st of last year? If you will, walk us through your route.
At 9:55,
You've already testified as to what you did. I just want you to repeat it and mark it on the piece of paper as you do so.
okay. At 9:55.
Your Honor, at this time I'd like to request to stand by the prosecuting attorney to observe.
At 9:55 on December 1st, I arrived at Raleigh's and I parked in the back. And I got out my car and I walked to the front of the building and knocked on the front door. And Emma, she came and let me in. And as I came in, she locked the door behind me. Then we went to the safe. We went to the office where the safe is. She unlocked the safe, and she took some checks and spread it around on the desk and on some on the floor. And she also took some $1 and $5 bills out there and spread them around. Then she took the rest of the cash out the safe, and it was $3,400. And so she gave me half, and I took my half, which was $1,700. I put it in my pocket, and she took the other half, the $1,700, and she put it in her purse. Her purse was also in the office. Then after that, we left out the office. We went to the back door, and the back door was locked. She unlocked the back door. I went out, and our plan was that she was supposed to lock the back door, but I'm not sure what she did. But after I got out, I went to my car, got in my car, then I went to my girlfriend's apartment, which was approximately 3 miles from
So
Wiley's.
you drove away from the rear of the building?
Yes, ma'am.
Okay, and you've marked this all on here.
Yes.
Is this an accurate representation now of the route that you testified to?
Yes.
Your Honor, permission to present to the jury?
Yes, you may.
Thank you. Nothing further, Your Honor?
Any cross-examination?
How you doing today, Mr. Hanley?
Just fine, sir.
You pled guilty to this crime, isn't that correct?
Did I plead guilty?
Have you pled guilty to this crime yet?
No.
You haven't pled guilty?
He confessed, Your Honor. That's been
I'm
already
playing.
testified to.
Okay.
So you have pled guilty?
Yes.
Okay. And isn't it true that you were testifying against Ms. Sands as a part of a deal?
No, sir.
Do you remember giving a deposition on February 4th of this year?
Yes, I did.
And in that deposition, there was a court reporter, wasn't there?
Yes.
And you took an oath at that deposition, didn't you?
Yes.
Same oath you took today, isn't that correct?
Yes, sir.
And that oath was to tell the truth, isn't that correct?
Yes, sir.
Now, Mr. Hanley, on your deposition, court and counsel, that would be page 11, lines 7 to 9, isn't it true that you stated, the prosecutor has requested leniency from the judge, and the judge said that my sentence would be less if I agreed to testify truthfully in this case? Did you make that statement?
Yes, I did.
Okay. And this deal is made with the prosecuting attorney, isn't that right?
I don't know. It's a deal.
These arrangements have been made with the prosecuting attorney, isn't that correct?
Objection, Your Honor. We have already stipulated that he has confessed to this. The prosecution has agreed to recommend a lighter sentence, but it will be at the judge's discretion in the end. And it also says in the same deposition, I have received no promises or threats in order to get me to testify. If there is any consistency in the deposition, it should have been resolved before.
I think it's objections overruled or is denied.
So you made this deal with the prosecuting attorney, isn't this correct? This arrangement.
Yes, we made arrangement where if I tell the truth, which I am telling the truth, that they would give me some leniency.
Don't worry, we'll get to that. And for testifying against Ms. Sands, they're going to recommend you receive a lesser sentence, isn't that correct?
If I tell the truth, yes, sir.
And in fact, if the prosecution they're recommending a sentence of 2 years of probation, isn't that correct?
They never informed me how much time, the time.
And all you have to do is testify against Ms. Sands.
The agreement was for me to tell the truth.
Okay, well, let's talk about the truth, Mr. Hanley. Isn't it true that you left Mr. Fox's store with $1,700 in cash?
Correct.
And after the robbery, you testified that you took an airport limo to the airport?
Yes.
And how did you pay for that limo?
Out are the $1,700.
Objection, Your Honor, beyond the record.
I'm just making a reasonable inference, Your Honor.
I get two conflicting things in our packet on what to do with these objections. Objections denied. Go ahead.
So you paid for these out of your own funds that you took from Wiley's package store, that's correct?
Yes, sir.
And then you testified you took an airplane to Miami, and did you pay for that airplane ticket with the funds from the money you took from Wiley's store?
Objection, Your Honor, this is beyond the record. We've been supplied with certain information for this trial, and that is beyond the record. There's no such evidence here.
Again, we're simply making a reasonable inference.
Sustained.
3 days after you got into Miami, you were arrested, isn't that correct?
Yes, sir.
And your brother turned over what money you had left from the theft, isn't that correct?
Yes, sir.
Objection, Your Honor. Again, in the record, it does not say left over from the theft. It simply says money within within Mr. Hanley's possession.
Give me 1 second on it. Let me refer to my-
It's assuming a fact, not an evidence.
Let's go on with it. I'll deny the motion. Basically, I think that's a possible reasonable cross-examination of the facts as we know them. So go ahead.
So the objection is overruled?
Is denied.
Denied. Thank you, Your Honor. So, your brother did turn over the money you had left from the robbery to the police?
He turned over the money that I had left. He turned over the money I had in the bag, and I don't know if I might have put some of my own money in the bag along with the $1,700 that Emma gave me from the Wiley's.
Really, isn't it? So you're testifying now that Emma gave you money?
Well, out the safe, yes. She gave me money out the safe.
I'm a little confused, Mr. Hanley. Now, you testified that you left the store with $1,400. Is that correct?
I left the
Objection,
store
Your
with $1,700.
$1,700. I apologize. $1,700. Okay. And now I've got one more question about the checks. You did testify that you scattered checks on the floor in the office of Wiley's package store?
Yes, we did.
I have no further questions at this time.
Incorrect.
Your Honor, I think we stipulated that we were not going to have redirects in the process. I think that was,
I was not aware, but if that's the case, that's fine.
that's what we were told.
Is that in the rule?
I didn't read it.
I don't remember reading that.
On our judge's sheet, there's no redirect though, so I guess we could logically conclude that.
I think I have it.
No, there's no score sheet for redirect, so.
There were some inconsistencies between the instructions that were given, but we'll go to.
Okay. Are we agreed that we're not going to do redirect, or okay?
Is he excused?
Your witness is excused. Thank you. But the other can take you back to custody. Okay. Prosecution ready to call their next witness?
If I could take a second, Your Honor. Your Honor, I would like to call Officer Donna Patton to the stand, please.
Under oath, Ms. Patton.
Good afternoon, Mrs. Patton. Officer Patton, how are you?
Fine, thank you.
Could you please introduce yourself to the jury for me?
My name is Donna Patton. I'm a detective with the Gulfport Police Department.
Okay, and could you also tell us what your capacity is in this case that we're
I'm the
talking
case
about today?
detective.
Okay, thank you. Could you tell me where you were and what occurred on the morning of December 1st, 1994?
I was dispatched by
Objection, Your Honor. This is a multiple question.
I'll rephrase. Could you tell me what occurred? Could you tell me on December 1st, do you remember where you were on December 1st, 1994?
Yes, I was in my patrol car.
What happened right at 10 o'clock or right around the hour of 10 o'clock in the morning?
I was dispatched to Wiley's package store. There was an alleged armed robbery, and I went to investigate the situation.
Okay. So you went to Wiley's package store?
Yes, I did.
Okay. When you arrived at Wiley's package store, did you find someone there?
Yes, I did.
Could you tell the jury who you found there?
I found Ms. Emma Sands. She was standing outside of the package store, speaking very loudly, gesturing to bystanders, carrying on about a robbery that had allegedly occurred.
Okay, and did you go to talk to Miss Sands?
Yes, I did.
Okay. Could you please tell the jury what Miss Sands said to you at that time?
Ms. Sands claimed that a man that she only knew by the name of Tom had entered the store. He had gone in to use the bathroom, but he went from the bathroom to the office, and in the office he drew a small pocket knife on her, said he was going to take the money, pushed her aside, took the money. It was approximately $3,000. He ran out the front door, according to Ms. Sands, and the reason the money was out was she was getting ready to put it in the cash drawer to open the store at 10 a.m.
Thank you. So, let me just clear this up. A few questions. She told you that he came through the front door.
Correct.
He went to the back, to the restroom, which we'll talk about in just a second.
Yes, he did.
And then to the office, and then she says that he left through the front door.
Yes, she does.
Okay. Your Honor, may I approach the witness?
Yes, you may.
I am showing the witness State's Exhibit B, which has already been offered into evidence, for the purpose of going through her testimony. Would the defense like to?
Yes, Your Honor, they would approach.
Yes, you may.
To avoid confusion, I'm giving the witness a green marker as opposed to the red marker that was used before. It is your testimony that Ms. Sands has told you that Mr. Hanley came to the front door.
Correct.
Could you please point out the front door? Okay. After that, you've told the jury that he went to the restroom. Could you put an X on the restroom? You've also told the jury that he then went into the office where he held a knife and stole the money. Could you put an X on the office? Now, you've also said that she said that he exited through the front door. Could you draw a line from the office to the front door to show how he exited? Thank you. I'm going to have another question for you in just a second. If you could please hold on to that. After she told you this, was there anyone else at the front of or anywhere around the liquor store?
Yes, there was. There was a bystander named Danny Tarver.
And did he say anything to you?
Objection, Your Honor, hearsay.
This is a logical inference. It's going from a stipulated fact of a license plate number given to us by Danny Tarver, and it's a logical inference that what he said, if he was able to give the license plate number, he must have seen the car, which is going to be what is the testimony.
Is that what you're objecting to? Is the inference portion or
I'm objecting to the what Mr. Tarver said to Detective Patton, because it is hearsay, Your Honor, as offered for the truth of the matter.
All right, sustained, but you can try it in a different way.
Okay, could I also argue the objection a different way? It is.
No, just go ahead and try it in a different way.
Okay. You received a license plate number that day,
Yes, Mr. Tarver handed me a note.
and it had
It had TLC 090 written on it.
okay, may I approach first, may I show the defense and then the witness, Exhibit A?
Any objection to this exhibit?
Your Honor, the objection is that it's still hearsay.
Your Honor, I would like to reiterate the argument that it's a logical inference. However, I would also like to add that as a spontaneous statement under 803.3, it was a statement that was made right after the crime took place, and it has been a stipulated fact. At least the part that I'm adding right now is a stipulated fact by both parties.
Or what is stipulated? That that's what
The stipulated
on the piece of paper?
Stipulated fact is that there is a license plate number on this sheet of paper.
Response.
Your Honor, this testimony is irrelevant. It has little probative value.
I disagree. It does have probative value. It is arguing that another witness was there that day that could have seen the individual that took the money, and that person gave a spontaneous statement to the police officer at that moment, which could be probative towards the facts of this case.
Motion is denied.
Thank you, Your Honor.
May I approach the witness?
Yes, you may.
Have you ever seen this?
Yes. This,
Could you tell me what it is?
this was the license plate number that was handed to me by Danny Tarver, a bystander at Wiley's Package Store.
And with this, did you do anything with this once he gave it to you?
Yes, I did. I found out that that license number is attached to a gray 1985 Ford LTD that is owned by the defendant, the gentleman who robbed the package store's girlfriend by the name of Carol Hunt.
Okay. And did Mr. Tarver tell you anything else while he was there?
Objection, Your Honor. Hearsay.
It goes back to a logical inference, Your Honor, from the fact that he received a license plate number. If he received a license plate number, he obviously saw a car. I'm not arguing to prove the truth of the matter asserted, just that there was a car attached to this license plate number.
Mr. Carver is dead, right? That's part of the stipulation.
Yes.
So his deposition would be offered somewhere, presumably in this case. Sustain the objection.
Thank you, Your Honor.
Okay, Your Honor. After you received the license plate number, can you tell me what the next thing you did was?
Yes. The next thing I did was to broadcast a bolo, which means be on the lookout for the car with that license plate number, since it may have been involved in this robbery.
Okay, and after you did that, I'm sorry.
After I did that, I made a drawing of the package store.
The drawing that you
The
have in front of
drawing
you?
here accurately depicting the interior of the store.
Okay. After that, did you happen to talk again to Mrs. Sands?
Yes, I did. She told me that she...
Objection, Your Honor. Hearsay.
After this, after you talked to Miss Sands once again,
Go ahead.
after you talked to Miss Sands once again, what was the next thing that you did?
After I did that, I checked the alarm system in Wiley's Package Store.
And can you tell me about the alarm system?
The alarm system was in perfect working order. There were alarms both under the office desk where the money was and near the cash register. Neither was turned on, tripped. Both would have worked had they been.
Okay, thank you. Did you happen to search the entire liquor store?
Yes, I did. There was no knife in the area surrounding the store, in the store, parking lot. No knife was found. No evidence of physical injury to Ms. Sands. We found some loose 1s and 5s scattered on the floor, some bank checks neatly stacked on the desk.
I would like to ask you one more time. When you saw Danny Tarver and he handed you the license plate number that we have before us, did he happen to mention, let me rephrase, did he happen to mention that there was a car present, that he had happened to see a car earlier that morning?
Yes, the car with the TLC 090 license plate drove away from the rear of the store at approximately 10:05.
Thank you. After you left the liquor store that day, what was the next thing that you did?
I went to see Carol Hunt, Thomas Hanley's girlfriend and owner.
Thank you. When you saw Miss Hunt, after you left Miss Hunt, where did you go?
I went to see, I issued a warrant for the arrest of Thomas Hanley, and I was notified by the Miami police that he was already in custody, so I drove to Miami to speak to him.
Why did you go to Miami?
2 reasons. One was I was informed by Ms. Hunt that Hanley had a brother
Objection,
in
Your
Miami.
Honor. Hearsay.
And secondly,
Wait a minute. Was it hearsay why she went to Miami is hearsay?
No, Your Honor, the witness is testifying as to what Carol Hunt informed her of.
That's fine, Your Honor.
You withdraw the question.
I withdraw the question.
Okay.
You went. Can you tell me again why specifically you went to Miami?
I went to Miami because I was notified by the Miami police that Hanley was in custody in Miami.
Had you, when the Miami Police Department had told you that he was in custody in Miami, had they mentioned anything else to you?
He wished to confess.
Okay, so when you went down there, you went to talk to him
To take
in
his
consideration
confession.
of a confession.
Correct.
When you arrived in Miami and you talked to Mr. Hanley, what did he tell you?
Objection, Your Honor. Hearsay.
The declarant was available for cross-examination.
At the time he made the statement.
No, he wasn't, but he has been in court today.
Your Honor, it's still an out-of-court statement that's offered to prove the truth of the matter asserted.
Sustained.
Okay. Officer Patton, while you were there, did you promise Mr. Hanley anything?
No, I did not.
Did he make a confession to you?
Yes, he did.
Did he admit to the events that took place?
Yes, he did.
Did he tell you of a conspiracy?
Yes, he did.
Objection, Your Honor. Hearsay.
Sustained. Disregard the answer.
If I could take a moment, Your Honor. Officer Patton, did you arrest Thomas Hanley at that time?
Yes, I did. I arrested him, took him into custody, and brought him back to the Pinellas County Jail.
What was the next thing that you did after you brought him back?
Well, right before that, he got a telephone call. He's allowed to make a call, and he placed that call to his brother.
I'm sorry. Was there anything that you did before you left Miami?
Yes, I did. He was allowed to make this call, and he called his brother, who met me at the county jail, and handed me $1,877 in 1s, 5s, 10s, and 20s.
And then you took him back to Pinellas County?
Yes, I did.
Okay, once in Pinellas County, what was the next thing that you did
The next thing I did was
relating to this case?
have Emma Sands come and speak with me at the Gulfport Police Department.
Did you advise Miss Sands of her rights?
Absolutely.
And did she talk freely without a lawyer present after you had advised her of her rights?
Yes, she did.
After you talked to Miss Sands that day, where did you go?
At about 5:30, I went to her apartment.
When you arrived at her apartment, did you tell her you were there to search the apartment?
Yes, I did. I told her I was there to search the apartment. She opened the front door.
Did she say anything to you?
Objection, Your Honor. Hearsay.
What's your response?
I'll try and rephrase the question. Did you search Miss Sands' apartment that day?
Yes, I did. She opened the front door, stepped aside, and allowed me to enter and search her apartment.
While you were in her apartment, did you find anything?
Yes, I did.
Objection, Your Honor. At this time, we'd like to renew our motion in limine and ask that you read the limiting instructions.
Let me see what you have proposed in terms of limiting. And has the other side seen your proposed
No.
limitation? Show this to the other jurors, the other judging jurors. What's the response of the prosecution?
Okay, I'm sorry, Officer Patton, while you were at...
We have a motion pending.
I'm sorry.
To limit, for a limiting instruction on this answer to the question you've asked. There has not been an answer yet. What is your response to the motion? First of all, there's been an objection to the testimony.
Well, Your Honor, the evidence that we are about to present is not being offered for the truth of the matter asserted. It's merely being offered to prove the presence of the evidence, which would fall under their limiting instruction. So it would seem... Your Honor, may I take a second? This limiting instruction, however, Your Honor, I would like to limit the instruction to merely dealing with the note which will be presented into evidence and not the money which will be presented into evidence.
The objection, as I understand, is only to the note.
Exactly, Your Honor.
As far as the limiting, well, the objection to the testimony is denied. Now, as to the limiting instruction, do you object to the wording of the limiting instruction?
Yes, I do.
And what is that?
Second line, it says you may only consider the fact that the evidence was found only, well...
Your Honor, may I approach the bench?
Yes, you may.
Your Honor,
Wait a minute. Let me see what she says. Go ahead.
I would like to merely add, you may only consider the fact that the evidence, comma, the note, comma, was found at the defendant's apartment so as not to limit the consideration of any evidence that might have been found at the defendant's apartment.
What about this last sentence? You may not consider the truth of the evidence. Isn't that what you want?
I'm not offering the exhibit to prove that what was written on the exhibit was actually quote-unquote true, but merely that it was found in her apartment.
I'm going to deny the request for the limiting instruction, and then you're, of course, free to cross-examine on the point as far as the weight is to be given, the circumstances it's found under, and all of those types of things.
Officer Patton, was there anything that you found in the apartment while you were there?
Yes, I found both $543.23 in Miss Sands' purse, which was on the kitchen counter, and I found a note that was in her son's bedroom between the mattress and the box spring.
Your Honor, may I approach the defense?
Yes.
May I approach the witness?
What are you going to show?
I would like to offer Exhibit C to show the witness Exhibit C. States it.
Okay.
Do you recognize this?
This is the note that was in her son's bedroom between the mattress and the box spring.
Before you do anything, is there any objection to this note?
Pardon me, Your Honor?
Do you have any objection to this note?
No, Your Honor.
Go ahead.
Is this in the same condition as it was when you last saw it?
Yes, it is.
I would like to offer Exhibit C into evidence.
No objection, Your Honor.
Okay, you may.
Could you please read what is written on the note out loud, please?
12-5 HOT 10 WEEK.
Okay. Thank you. Permission to show this note to the jury?
You may.
Just to reiterate, or just so I can specify, in the purse where you found the $543 in Miss Sands' apartment, did you find anything else in the purse other than the money?
Yes, I did. I found Sands' Florida driver's license.
Okay. No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Detective Patton, you mentioned that Tom Hanley's brother met you at the jail in Miami, correct?
Correct.
And isn't it true that you received $1,877 from Mr. Hanley's brother?
Yes, I did.
You said you searched the inside of Wiley's liquor store after the robbery, didn't you?
Yes.
And you said that you saw some checks neatly stacked on the desk, correct?
Correct.
While you were at Wiley's liquor store investigating the robbery, did Miss Sands identify the robber?
She said she would be able to identify the robber as a man she knew as Tom, who had been working out in front of the store.
Did she identify him to you?
Objection, Your Honor.
And the basis for the objection?
Hearsay. Right now, we do not have the declarant. She's testifying to the truth of a matter asserted of a out-of-court statement.
What's your response?
Your Honor, this is an exception to the hearsay rule for identification.
Okay, yeah, overruled.
Who did Ms. Sands identify as the robber?
A man named Tom, one of 3 men who had been working out in front of the store, the only one that she did not like.
Detective Patton, isn't it true that you met Emma Sands at the police department on December the 8th at 10:30 a.m.?
Yes, I did.
And that meeting was over at 12:15 p.m., correct?
Correct.
Isn't it true that you went to Emma's apartment at 5:30?
Yes, I did.
So you had from 12:15 until 5:30 to get a search warrant, correct?
No, the paperwork was not completed until 4 p.m., at which time there were no judges available. So I really only had from 4 to 5:30 to get a search warrant, and there were no judges available to give me one.
So it took you 4 hours to complete the paperwork?
Yes,
And in those 4 hours, you failed to get a search warrant, didn't you?
yes, I did. The search warrant can't be obtained until the paperwork's complete, and that wasn't complete until 4 p.m.
So you searched Emma's apartment without a search warrant, didn't you?
Yes, I did, with her consent.
During your search, you found a piece of paper with some writing on it at Emma's apartment, correct?
Yes.
You don't know who wrote that piece of paper, do you?
No.
Thank you, Your Honor. No further questions.
Any other witnesses for the prosecution?
No, Your Honor, the state rests.
No.
Yes,
Did the jury take a bathroom break?
yes, you're, do you want to wait till after motions first? Or
Okay.
okay. Is there any motions by the defense?
Yes, Your Honor, there is.
What length of time do you think it's going to take to present these motions?
Just a couple minutes.
Keep in mind the needs of the jury.
This is, we move for a motion for judgment of acquittal at this time, Your Honor. The prosecution has failed to meet its burden of proof as set forth in Christie v. State. The prosecution has not set forth a prima facie case for going forward with the evidence. They have not proven the location of this crime, that it was at Wiley's Package Store, which is located at 1301 61st Street South. The prosecution has not proven the venue of this crime, which is in Pinellas County. The prosecution has not proven the identity of Ms. Sands in the courtroom today. Your Honor, their evidence, no reasonable juror would believe their evidence as it stands.
And the response by the prosecution.
Your Honor, we would want to review the record to see that the venue is not established. I believe that our officer did state the location of Wiley's Package Store. The defendant was referred to as Emma Sands, who is present in the courtroom. And we would state to you also that this is a prima facie case. The preponderance of the evidence, especially if after the defense presents its case, we would be able to impeach witnesses and corroborate our case, which would lend to the preponderance of the evidence on our side.
Have you done it all? Have you met every element, the facts to prove every element of your case in your presentation?
I believe we have, and I believe that they're objecting to venue, which...
Forget venue for a moment. The other elements of your case, have you met the other elements of your case? And what evidence has shown those?
We have given evidence of a witness who has said, the testimony of, for example, Mr. Hanley, who has testified as to what he purportedly, with the defendant Emma Sands, did do that day, which would meet the elements of the crime. The factual basis should actually go to the jury. It is to the jury to determine factual questions, and that's a much higher level of evidence that's required there. However, for a motion for judgment of acquittal, we don't believe that we have failed the standard for that, and we believe that we should proceed.
Your Honor, we submit that the prosecution has failed to prove that Emma Sands knowingly and unlawfully obtained the money of Wiley Fox.
However, we did have a witness who testified to the fact that she knowingly did do so. We do have a witness who did testify to that. If that is not testifying to the elements of the crime.
The motion is denied. You thought you were going to get the homework. All right, we're going to take a break for, we're doing real good on time. How much time do you have?
10 sufficient.
By the courtroom clock, we'll be back here at 10 till 8.
Oh, all rise. Sorry.
Yeah.
Can she go?
You're free to leave.
Don't you have to tell us not to
We leave you hanging up there.
We have to keep the media away from... But I've got to keep... I've seen him do it before. It's a court reporter, man. I've seen her never hooked. Well, what's he going to say?
Would you take it?
Is the defense ready to proceed?
Yes, Your Honor, we are.
Call your first witness.
We'd like to call Wiley Fox to the stand. Mr. Fox, would you please introduce yourself to the jury by stating your name?
My name is Wiley Fox.
And would you please tell the jury what you do for a living?
I own Wiley's Package Liquor Store in Gulfport, Florida.
On December 1st, you were robbed, isn't that correct?
Yes, that's correct.
Did you ever determine what your losses were from that robbery?
Yes, it was $3,417.
Did you have the opportunity to survey your store after the robbery?
Yes, I did.
Did you inspect the office?
I did.
Was anything scattered on the floor?
There was money scattered on the floor.
What about checks? Were there also checks scattered on the floor?
No, the checks were stacked neatly on the desk.
So all the checks were stacked neatly on the desk?
That's correct.
Do you know Emma Sands?
Yes, I do.
How do you know her?
She's worked for me for the past 3 years in the store.
Before the robbery, did Miss Sands ever mention Thomas Hanley to you?
Yes, she did. She mentioned that he was working out in the parking lot, paving the lot.
Did she ever complain about his behavior?
Yes, she said that he was creepy and he was hitting on her.
Objection, Your Honor, hearsay.
Overruled. You already answered the question.
So, during the years you have known Miss Sands, have you known other people in the community in which she lives who also know her?
Yes,
Who are these people?
many people, members of our church, members of the Cheyenne Social Club, which we both belong.
And have you ever been present when these people have discussed Emma Sands?
Yes, I have.
How many persons have you heard discuss Emma Sands?
At least 25,
And how many times have you heard them discuss Miss Sands?
about 100 times.
Have you heard the reputation of Emma Sands for honesty? and
Objection, Your Honor, beyond the record.
First of all, let him finish the question. Second of all, stand up when you make
I
an objection.
apologize, Your Honor.
All right. The objection is, did you finish the question?
No, Your Honor.
Okay. Ask the question again.
Have you heard the reputation of Emma Sands for honesty in the community in which she lives as it was around December 1st, 1994?
Yes, I have.
Wait a minute. Okay. Okay, that's... All right, go ahead and ask your next question.
And what was that reputation?
All right, now, is there an objection?
There is an objection that it's opinion and hearsay as to all of the people in the community that's commenting on her.
All right, and What's your response?
Your Honor, this is not opinion testimony, this is strictly reputation testimony and is allowed in under the Florida Evidence Code.
What section?
Can I refer to
Sure.
my notes? Methods of proving character, statute 90.405. Reputation, when evidence of the character of a person or a trait of his character is admissible, proof may be made by testimony about his reputation.
Has there been evidence concerning the character of
Well, my specific question
Sam's?
was her reputation for honesty, and that goes directly for the alleged crime at hand.
Well, has anyone got up and said she was dishonest?
Well, honesty goes hand in hand with grand theft.
Any response from the prosecution?
I would just like to reiterate the objection against offering all of this evidence towards community members who we will not be able to cross-examine in court today, towards their comments towards Ms. Sands.
Overruled. You can answer the question.
Yes, she had an impeccable reputation for honesty.
We have no further questions.
Cross-examination.
Mr. Fox, do you have a policy at your store about arriving and opening times?
Yes, I do.
And is that at 9:45 that you are to open the doors?
No,
Or is it 9:45 that your employees are supposed to arrive at the building?
that's correct.
And they're supposed to open the doors at 10:15.
That's correct.
So before 10:15, they would not be open to the public.
That's correct.
So anybody that was to enter the building before 10:15 that was not an employee should not be in your building before 10:15.
Yes, that is correct.
No further questions, Your Honor.
Okay, you may step down. Call your next witness.
Your Honor, the defense calls Emma Sands.
Would you please state your name for the court?
Emma Sands.
How old are you, Miss Sands?
I'm 28.
Where do you live?
I live at 2227 49th Street South here in Gulfport.
Are you married?
No, I'm not.
Do you have any children?
Yes, I have a 5-year-old little boy.
What is your occupation?
I work at Wiley's liquor store
And how long have you worked there?
for about 3 years now.
Miss Sands, why did you take a job at Wiley's liquor store?
After my divorce, I had a child to support and I needed to pay the bills.
And can you pay all of your bills?
Yes, I can.
What time do you usually come into work at Wiley's?
About 9:45 in the morning.
And what do you usually do when you come in?
I open the front door, I go into the back of the store, into the office, I open up the safe, I retrieve money, put it on the desk in different denominations before I put it into the cash register.
Miss Sands, do you know Thomas Hanley?
Yes, I do.
And how do you know him?
He was paving the parking lot outside of the store approximately in November.
How did you feel about Mr. Hanley?
I didn't like him at all. He gave me the creeps.
And why is that?
He asked me out several times and made several unwanted advances towards me.
Your Honor, may I approach the clerk?
Yes, you may.
May I approach the witness?
You may.
Ms. Sands, I'm showing you what has been pre-marked as Defense's Exhibit 1. Do you
Your Honor,
recognize it?
excuse me, we object. This has not been shown to the prosecution.
Your Honor, I was going to ask her a couple questions and then admit it into evidence and show opposing counsel before we do anything with it.
Well, that's all right. Show them what it is you're showing the witness. They're entitled to see that.
Thank you.
Ms. Sands,
Yes.
I'm showing you what has been pre-marked as Defense Exhibit 1. Do you recognize it?
Yes, I do.
And how do you recognize it?
It's a diagram of the store where I've worked for 3 years.
Would you say this is a fair and accurate representation of the inside of Wiley's Liquor Store on December the 1st?
Yes, I would.
And would it help you to explain what happened?
Yes.
Your Honor, at this time, we offer into evidence Defense's Exhibit 1 for identification. Let the record reflect that opposing counsel has seen the exhibit.
Any objection?
No, Your Honor.
Okay, you may.
Your Honor, at this time, may we publish the exhibit to the jury?
You may.
Your Honor, may the witness step down and approach the exhibit?
Yes, you may.
Ms. Sands, would you please stay to the left side of the exhibit?
Yes.
Okay. Now, Ms. Sands, what time did you arrive at Wiley's Liquor Store on December the 1st?
About 9:45 in the morning.
And what did you do when you arrived?
I opened the door and went into the back where the office is located. I went to the safe and retrieved the money, put the money on the desk, and began to separate it into denominations.
Would you please put an X in the office where you were? And would you please put an S by where the safe was located?
Yes.
And then what happened, Ms. Sands?
Then I heard a knock at the door.
Would you please place a D beside where the door is located?
Yes.
And who was at the door?
Thomas Hanley.
And did you let him in?
Yes, he had to use the bathroom, and he had been in several times to use the bathroom before.
Objection, Your Honor, beyond the record. There's nothing in the record to indicate that Thomas Henley had ever been allowed in by Ms. Sands under these circumstances ever before.
Your Honor, this is a reasonable inference.
Your Honor, I would disagree with that. It's not a reasonable inference.
Objection sustained. Go on.
Now, Ms. Sands, when you let Mr. Hanley into the store, where did he go?
I escorted him from the door into the back and into the bathroom, which is located right next to the office.
Would you please circle where the bathroom is?
Yes.
And when he came out of the bathroom, did he leave?
No, he did not.
Where did he go?
He entered into the office where I was, and he put a knife to my throat. He pushed me down on the floor. He grabbed the money from the desk and ran back out the front door.
Thank you, Ms. Sands. You may be seated. Does Wiley's have an alarm in case of a robbery?
Yes, they do.
And did you switch on the store alarm?
No, I did not.
Why not?
I really don't know. I was so panicked and scared. I just wanted to let someone know that I had been robbed, so I just ran out and followed him and just was trying to get the first person I could see to let them know that I had been robbed.
Miss Sands, did you conspire with Thomas Hanley to commit this crime?
No, I did not.
Did you participate in any way in this crime?
No, I did not.
Did you receive any benefit from this crime?
No, I did not.
Thank you, Miss Sands. No further questions.
Cross-examination.
Ms. Sands, you have testified on the stand, and your boss, Wiley Potts, has also testified that you did not like Thomas Hanley, did you?
No, I did not.
And you didn't like him because he hit on you.
That's correct.
He made unwelcome advances toward you, didn't he?
Yes, I did.
You testified you didn't like Thomas Hanley, and yet you allowed Thomas Hanley in the store, didn't you?
To use the bathroom.
Yes or no, please?
I'm sorry, what was the question?
Did you allow Thomas Hanley in the liquor store?
Yes.
20 minutes before opening time, 9:55 a.m., whereas you were not supposed to open the doors until 10:15 a.m. to the public, correct?
That's correct.
So you opened the doors 20 minutes early, to admit a man that you've already said gave you, quote, the creeps, a man that you did not like who had made unwelcome advances towards you. You were alone in the liquor store when you let him in, were you not?
Yes, I was alone.
Okay. You allowed him in the front door. You did violate your boss's policy, didn't you, by opening the front door 20 minutes early?
Objection, Your Honor. This is beyond the scope of the record.
Policy has been stated, Your Honor. Mr. Fox testified that his policy is that employees arrive at 9:45, open the doors at 10:15.
But, Your Honor, it does not violate any policy about letting other people into the store before. Wiley Fox did not testify to a policy about letting other people into the store before the store opened.
He testified that the front door is not to be open until 10:15 a.m.
Overruled. Go ahead.
So you did violate your boss's policy by opening the front door 20 minutes early to allow Tom Hanley in, correct?
I suppose.
Yes, you did. And and you were alone. No one else was in there.
That's correct.
You had just taken money out of the safe, you said,
Yes.
to get ready to open the store in a few minutes. You had the money stacked on the desk in the office,
Correct.
and you have stated that the office is right next to the restroom.
That's correct.
They share that common hallway, don't they?
Yes, they do.
So you allowed Tom Hanley in to use the restroom,
Right.
knowing that this money was stacked on the desk.
I-
Yes or no, please?
Yes.
After Tom Hanley allegedly robbed you, you didn't sound the alarm, and you have no explanation other than you blanked out?
That was not my explanation. My explanation was that I was panicked and I didn't know what to do.
That
And I
you
knocked
pretty
on the
much,
door.
sorry, but you pretty much said that you panicked, you
Right.
didn't think to press the alarm.
That's correct.
Not sounding this alarm probably delayed the apprehension of Tom Hanley, didn't it?
I wouldn't know.
To your knowledge, would you expect the police to respond promptly when you pressed the alarm?
Yes.
And yet you did not press the alarm. Is it not a logical inference that the police would take longer to respond by not responding to the alarm?
Objection, Your Honor. Speculation.
Logical inference, Your Honor.
Sustained.
When you saw Officer Patton, who responded to the call,
Yes.
you told Officer Patton that the robber was someone you knew only as Tom.
Correct.
After Danny Tarver spoke with Officer Patton, and after Officer Patton came in to look at the store, you offered to identify Hanley at that point, did you not?
I believe so, yes.
But you did wait until after the inspection of the store and until after Officer Patton had spoken with Danny Tarver.
As to my recollection, that's correct, but the chain of events were so
Yes.
that they wanted to inspect
Is
the
that a
store.
yes?
That is yes, I believe so.
Thank you. Would you not say that the longer it took for law enforcement to find Tom Hanley, the longer the space of time before Tom Hanley would speak to the police?
I don't really know the answer to that question. I'm not in law enforcement. I have no idea.
It's a
the
very
policy.
basic inference of logic.
I'm
If
not
it takes
logical.
Objection, Your Honor. Speculation.
Your Honor, if it takes the police longer to get to Thomas Hanley, then obviously it would take longer for Thomas Hanley to speak with the police.
Sustained.
You told Officer Patton that Tom Hanley ran out the front door,
That's correct.
yet as far as you know, no one saw him.
I don't know. I don't believe so.
But when you came out the front door, you found a bystander right away to whom you were speaking when Officer Patton arrived on the scene.
That's correct.
And as was testified earlier, this bystander did see Tom Hanley drive away from the rear of the building, yet he did not testify that he had seen Tom Hanley come out the front door.
I don't know. I'm
When you
sorry,
were
I
s-
don't understand the question.
When you were standing there,
Objection, Your Honor. Argumentative. Counsel is arguing with the witness.
Sustained.
Officer Patton found $543.23 in your wallet, which had your driver's license, correct?
I believe so.
And Officer Patton also found a note in your apartment, which has been shown to the jury.
I don't know. I never have seen that before, so I don't know if she found it or not.
Officer Patton did not question you about the note then?
No, she
Or about the money?
No.
Okay. Nothing further, Your Honor.
Any more witnesses for the defense?
No, Your Honor.
May step down.
Sorry.
Any other evidence to be presented by the defense?
No, Your Honor, we rest our case.
I don't know what the rules are on rebuttal witnesses. Do we have any of those, or we're just staying with what we got? Any more witnesses for the defense?
No, Your Honor.
You may step down.
Sorry.
Any other evidence to be presented by the defense?
No, Your Honor, we rest our case.
I don't know what the rules are on rebuttal witnesses. Do we have any of those, or we're just staying with what we got?
That was waived.
Is there any additional motions by the defense?
We are ready to go ahead with our closing argument, Your Honor.
Are you sure you don't want to make a motion?
I'm positive.
Okay. Let me ask you all, do you need a few minutes to talk to each other before you actually do the closings? Are you ready to do them, or what's your pleasure on that?
5 minutes?
Whenever we're ready to go.
Do you need 5 minutes?
5 minutes is good.
Yeah, we'll give you a couple minutes to
Thank you.
talk about it, how you want to. Are you ready to proceed?
Yes, Your Honor. May it please the court, counsel, members of the jury. Ladies and gentlemen, this is a case, a simple case, of one co-conspirator double-crossing the other. The defendant, Emma Sands. I'm sorry, should I wait for the defendant to come back? I didn't notice she wasn't there. I'll start over. I'm sorry.
I must have misjudged your time.
Let's rewind that tape there.
The defendant has the right to be faced by your...
Yeah, right.
Okay, proceed. And if you want to move that any way you feel more comfortable with.
I might move it this way. Let's do that. And it's not on those. Ladies and gentlemen, this is a case of one co-conspirator double-crossing the other. The defendant, Emma Sands, allowed Tom Hanley, a man she purports not to like, into Wiley's liquor store 20 minutes before opening time, allegedly to use the restroom. She would have us believe that she played no part in the robbery that took place that day. But ladies and gentlemen, Thomas Hanley has told us a completely different story. He has told us that he came to the front door on a prior arrangement with Emma Sands, and that Emma Sands allowed him in according to a plan. He came in, they staged the robbery together. Thomas Hanley exited through the back door of the liquor store. Emma Sands came out the front door, crying thief. The evidence that you have seen in this case does not support the defense. The evidence that you have seen supports the state's case that Emma Sands' story has many holes in it. The state saw through those holes in her story. We saw through the inconsistencies in the alleged version of events that she gave for that day. We felt secure enough to go forward with this case, and we have proven to you beyond a reasonable doubt that Emma Sands did commit the crime of grand theft. Let's begin with that front door. Now, the defendant has said on the stand and has told other witnesses that she did not care for Thomas Hanley. She is a woman coming to open a liquor store alone in the morning, 20 minutes before she could expect anyone else to come into the store. After she has just stacked up all the money she's going to use that day to open the store onto her desk, she allows a man that she has told us, quote, gives her the creeps, a man who has made unwelcome advances toward her, a man that made her uneasy, into this store. You all saw the diagram of the store. The front door is at a completely different end from the office where the robbery took place. Now, why would Emma Sands go open the front door to a man who she said made her uncomfortable, bring him into the store, all the way to the very back of the store, allow him to use the restroom, purportedly, even though the restroom is immediately next to the office where she has stacked up thousands of dollars? He could easily see the money if he was walking into the restroom. The restroom and the office share a common hallway. Why would Emma Sands bring such a man into her place of work, jeopardizing her job, jeopardizing her own safety, unless Thomas Hanley was supposed to be at the front door that morning at 9:55 a.m. and Emma Sands was supposed to open that door for him, unless it was prearranged, and unless Emma Sands has conspired with Thomas Hanley to commit this robbery. Wiley's liquor store has an alarm system. Emma Sands has worked at this store for 3 years. During those 3 years, surely she knew that there were buttons beneath the desk, on the counter by the register. She had plenty of opportunity to depress the buttons for the alarm to summon help from the police, and yet she didn't do so. And the only explanation she can give is that she panicked. She did not have one opportunity to depress the button when the alleged robbery was taking place, alleged armed robbery. If he did have a knife to her neck, perhaps she could have depressed the button at the desk. But when she ran to the front of the store, she says Thomas Hanley had already run out the front door. She could have depressed the button by the register on her way to the front door. She could have summoned help long before help actually arrived. After 3 years at the store, Emma Sands suddenly did not know what to do. Working in a liquor store, being a woman, opening by herself, knowing that every day there is always a chance of being robbed. Anyone in any retail business knows this. And yet she could not think of what to do the day when she was robbed. Not depressing the alarm bought Emma Sands time. By the time the police arrived, Thomas Hanley was well on his way. There was an eyewitness who gave the tag number to the officer, who made it much easier to identify Thomas Hanley. When Thomas Hanley was apprehended, the first thing he did was confess. And during this confession, he started telling police about the conspiracy between him and Emma Sands. Emma Sands surely must have known that this is what Tom Hanley would do as soon as he was apprehended. By not depressing the alarm, she bought some time. By not telling Officer Patton immediately that she knew who the robber was, she bought some time. You remember that Thomas Hanley told us that they divided the money evenly. She placed half into her purse, and he took half with him. What if the police had apprehended Tom Hanley right away? Tom Hanley would that much more quickly have revealed the conspiracy. And that much more quickly would there have been reason to search Emma Sands' possessions. And that much more quickly would it have been discovered that Emma Sands had participated in the scheme. Excuse me. The money amounts that have been referred to in this case also match up. Thomas Hanley has testified that their agreement was to steal approximately $3,400. And Wiley Fox has testified that his losses were just over $3,417. Now this right here corroborates Thomas Hanley's story. The defense would have you believe that what Thomas Hanley's brother turned over were the leftover proceeds from the robbery. But if you remember, Thomas Hanley met Emma Sands through his job. He had a job paving the parking lot. Are we to assume that Thomas Hanley did not have any money on him whatsoever, except for the money from the robbery? We can't make that assumption, and there's been no evidence given for us to even make an inference of that. Tom Hanley's brother turned over what money he found in Thomas Hanley's bag. And it's not that much over $1,700. It is a reasonable inference that he had some cash with him, as well as the money that he took from the robbery. And there was nothing given in the testimony that would have told us definitively that he did not have any other money with him other than the money from the robbery. All of this points to the conspiracy. The money amounts match up perfectly, give or take $17. Thomas Hanley has testified openly. He was not promised anything. The state may agree to recommend any sentence when a defendant in a crime offers to give testimony, but a final decision always rests with a judge. The judge who decides Thomas Hanley's sentence does not have to abide by the state's recommendation. The judge has the ultimate power to decide what his sentence will be. We may make a recommendation, but it will not determine his sentence. And Thomas Hanley was advised of this when he spoke. And remember that Tom Hanley spoke before even considering any sentence. When he was arrested in Miami, he was the one who approached law enforcement. He's the one who first said, "I want to confess." And confess he did. He didn't confess in Miami. He waited for an officer from Pinellas County, Officer Patton. And he told Officer Patton exactly what happened. Emma Sands says that Thomas Hanley came out through the front door of the shop. Yet both Tom Hanley himself and Officer Patton stated that Tom Hanley's car was at the rear of the store, not at the front. And you could see based on the diagram that was handed to you that there was ample parking on both sides of the store, and that to get from the front door to where he was parked, he would have had to pass several parking spots on either side of the store. This is not the most logical route that Tom Hanley would have taken were he committing an armed robbery. Emma Sands has testified that he held a knife to her throat to commit this robbery. That same knife to the throat could have been used to force Emma Sands to open the rear door of the store. He did not have to exit through the front door. He could have forced her to let him out the back door, and yet she says he went out the front, took the longest route possible to his vehicle, and took a chance that he would be spotted by bystanders. That just doesn't make sense. And then we also have the note that was found at Emma Sands' apartment. The note was passed around to you, and you were able to see what was written on it. Tom Hanley testified that they were supposed to meet December 5th, which could be written 12-5, that they were meeting at the Miami Beach Hotel. The note had the letters HOT. That they were meeting at 10 a.m., and that number was on the note. And that they were taking a week-long vacation. The word week was on this piece of paper. Now, whether we believe that Emma Sands was planning to meet Tom Hanley to go on this vacation, this piece of paper found in her apartment corroborates his testimony. The truth of it is not what's important. It's whether it was on the piece of paper and whether Thomas Hanley believed it. Thomas Hanley did, and that is what he testified to. Emma Sands did not even have to have any intention of following through with this plan, which is why the truth of the matter does not matter. The truth of the matter is not the important point. What matters is that the piece of paper states it. that Thomas Hanley believed it and that Thomas Hanley testified to it. Ladies and gentlemen, the evidence you have seen and heard here in this courtroom point to only one reasonable explanation, that there was a conspiracy between Thomas Hanley and Emma Sands, that this conspiracy was grand theft. The elements of grand theft were stated at the beginning of the case in opening arguments. When you receive your jury instructions for deliberation, they will be reiterated, and you will see that in order to prove our case, the state must have proved the three elements beyond a reasonable doubt. That Emma Sands knowingly and unlawfully obtained property which was not hers, which in fact belonged to Wiley Fox. That the property value was more than $300. It is undisputed that the value was well over $3,000. And that her intent in taking this property was to deprive Wiley Fox of it, or of its benefit, or to appropriate it to herself, or even to someone else who was not entitled to it. Ladies and gentlemen, we have proven that Emma Sands' story does not stand up as to what happened on December 1st of last year. Thomas Hanley has testified openly and without promises. He has told us about the conspiracy, and the facts will show, have shown you, that the only reasonable explanation is that this was indeed a conspiracy. The elements have been proven beyond a reasonable doubt, and the only just verdict, and the verdict for which we ask, is a verdict of guilty. Thank you.
Yes, you may.
May it please the court, counsel, members of the jury. Before I comment on the evidence, Emma Sands, Dina Marshall, and myself would like to thank you for your time tonight. We realize that you've made personal sacrifices to be here, sacrifices to your business, to your loved one, to your other obligations. And we realize that you do this not only because it's your civic duty, but because you want to make sure that justice is fairly administered in this courtroom today. Now, the prosecution has the burden to prove their case beyond all reasonable doubt. And they're relying on one witness to do this, Mr. Thomas Hanley. Now, Thomas Hanley is a thief and a liar. We know he's a thief because he's pled guilty to this crime. And we know he's a liar because of the inconsistencies in his testimony. Do you remember when Thomas Hanley was sitting right here, and I asked him about the checks that he had scattered on the floor? He said he scattered checks all over the floor. And the three other witnesses, Emma Sands, the owner of the liquor store, Wiley Fox, and the prosecution's own witness, Officer Donna Patton, have testified to the contrary, that those checks were neatly stacked on the desk. And then comes the discrepancy of the money. Now, you heard Mr. Hanley testify that he left that store with $1,700 in cash in his pocket. You also heard him testify that he paid for a cab to the airport, and he bought his plane ticket from Tampa to Miami, all with this money. And then the police recover $1,877. Now remember, he said he left with $1,700. And the prosecution expects you to believe, oh, he's got plenty of money. Sure, it's no problem. Well, you heard Mr. Henley testify that he was strapped for cash. Why would he rob a store if he had all this money? Now, that just doesn't make sense. Now, when you were asked to be jurors today, you weren't asked to leave your common sense at the door. It just doesn't make sense. Now, Thomas, in a few minutes, the judge is going to instruct you on some things that you should take into consideration when you're determining the reliability of a witness. The first thing is that witness's testimony conflicted with any other testimony or evidence. Well, you know it has. We just showed you that. The stacked checks. Another factor to consider is that witness being offered anything for his testimony? Well, I'm sure the prosecution would like you to believe that, of course, there's been no deal made, but the fact of the matter is, Thomas Hanley made a deal to testify if the prosecution would recommend a lower sentence. That means he probably won't go to jail. Now, of course, it is up to the judge to determine the sentence. The prosecution does have a lot of weight in that. And also, the judge will caution you in relying on a witness who claims to assist the defendant in this crime, especially when there is no other evidence to agree with his testimony. These are all things you must consider when relying on Thomas Hanley's testimony. Emma Sands. The testimony has proven she's got an excellent reputation for her honesty in this community. Now, she's a good mother. She's a hard worker. She took that job so she could support her child. She's a single mother. It's hard out there. You think she's going to put that job at risk for $1,400? And if she did put that job at risk for $1,400, do you think she'll just take off for a week on a vacation with some guy? Again, it just doesn't make sense. Prosecution has a burden to prove its case beyond all reasonable doubts. As for opening the doors, I found it kind of entertaining that the prosecution forgot to remind you that Thomas Hanley was an employee. He was working on that parking lot. There should be no reason that there's no policy broken in letting an employee come in to use the bathroom. As for the alarm, well, that's the funny thing happens when you panic. Sometimes you lose your ability to think rationally. Sure, a rational person may have set off that alarm. But Emma Sands testified that she panicked, and she had lost her ability to think rationally. That's why she ran out without depressing that alarm. And then comes the letter found at Miss Sands' apartment. Now, you heard no testifying linking that letter was written by Miss Sands. Hell, if I looked at it hard enough, I can make it look like anything. I'm sure if we all looked at it hard enough, there are many things that could explain this letter, and the fact that there is no evidence which links Miss Sands to that letter, well, that's got to be taken into consideration. The evidence has showed that Miss Sands was scared of Mr. Hanley. Now, when the prosecution said she wasn't expecting a knock on the door, she wasn't. That's why the money was out there. And when she let Mr. Hanley in to use the bathroom, what's she going to do? Now, the prosecution has failed to prove beyond all reasonable doubts its case. And we ask you to return the only verdict in this case which is possible, a verdict of not guilty. On December 1st, 1994, Thomas Hanley victimized Emma Sands. Please, don't let him do it again today in this court. Thank you.
No rebuttal either.
I didn't do a rebuttal. Forgot.
I used to have time.
Would it be allowable by defense? Do I have to defer?
We'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Ladies and gentlemen, the defense would have you believe that the strongest inconsistency in this case is the existence of the bank checks, the fact that they were stacked neatly according to 3 witnesses, the fact that Mr. Hanley said they had been scattered. Is that the only thing we have to say that is inconsistent? Can we decide this case simply based on whether the bank checks were stacked or whether they were scattered? What about the inconsistencies in Ms. Sands' testimony? What about the inconsistencies in what her behavior was and what a reasonable behavior would be? Mr. Hanley may have been an employee, technically. However, Ms. Sands was in the very back of the store. She was in her office. When Mr. Hanley knocked on the front door, she had no obligation to go open that door to him. She has said several times on the stand, and another witness also testified, she did not like Mr. Hanley and that she felt threatened by him. I would say that her allowing him into the store was not reasonable and was not to be expected. And if anything, that's even stronger than whether some bank checks were scattered as evidence. And if we're going to talk about who has money in their pocket and who shouldn't, Ms. Sands herself testified she's a single parent. It's tough making ends meet. Those of us with children know how true that is. And yet she had over $543 in her purse, which was hers based on the driver's license. Is that not also inconsistent? If we're going to question Mr. Hanley's possession of money, we have to question Emma Sands' possession of money. The note was in her apartment, and the note is so specifically tied to Mr. Hanley's testimony that we can only say that it corroborates. Ladies and gentlemen, please take all of this into consideration. And again, we ask for your verdict of guilty.
Thank you. You all have team numbers.
Team number? No, Your Honor.
Our score sheet has team numbers. I'll give the jury a few minutes to deliberate. If you all would like some critiques from the judges, I think we would be happy to give you some if you would.
We haven't received.
I want you to know that the teams that I've judged the last 2 years have won. So.
May we leave for a few minutes, Your Honor, or is that okay? Just
Sure, yeah.
Okay, thank you. Thank you.
Are we going to score the critique or something? Score or
Why don't you go ahead and score it, and then we'll do the critique.